topic under discussion today emanates from a specialized field of law. It caters to disputes between foreign investors and the government of a country or its organs and instrumentalities. These disputes could arise out of a host state regulation that could impact value of the foreign investment, discrimination against foreign investors as opposed to domestic investors, changes to the legal or regulatory framework of a country contrary to legitimate expectations of a foreign investor, so on and so forth. As a traditional remedy, foreign investors could pursue litigation against the state organs in the state courts. But what we are looking at today are alternate ways and means to settle disputes on a more independent international plane. That brings us to international investment agreements such as bilateral investment treaties or regional comprehensive economic partnerships between countries, where countries promise to protect and promote the investments of the signatory countries in the host state territory. As most of us know, such investment agreements or treaties usually provide for arbitration as a means of dispute resolution. However, the past decade has witnessed a surge of activity and criticism around investment arbitration and even around investment treaties. There is a growing need for reinventing the international landscape for resolution of investor-state disputes. Today, we are going to briefly explore the various mechanisms that foreign investors and states could explore to resolve their disputes. And with us in this session, we have none other than the very renowned and respected doyen of international commercial and investment arbitration, Mr. Gary Bond. Mr. Bond has participated as counsel in more than 650 international arbitrations, including 4 of the largest ICC arbitrations. He has been ranked for the past 20 years as one of the world's leading international arbitration practitioners and the leading arbitration counsel in London. We are all aware that he is widely regarded as the world's preeminent authority on international commercial and investment arbitration. A very warm welcome to you, Mr. Bond. I'm also joined today by my very avid colleagues and experts in the field, Shweta, Moazzam, and Vyapak. Mr. Bond, may I request you to give your preliminary thoughts on this topic before we dwell into the finer aspects, please?
I'd be delighted to. Thank you so much for the very gracious invitation to participate. It's an exciting topic, and thank you even more for the very kind introduction. This is an important topic. The protection of foreign investment has, over the last 5 decades, played, I think, a central role in the development of the world's economy, in the radical reduction in poverty all around the world, in quite literally the creation of today's economic system. The COVID virus pandemic at the moment has thrown that system into some disarray, but its essential fundamentals rest in significant part on the protection of foreign investment, and bilateral investment treaties and multilateral investment treaties like the Energy Charter and the ICSID Convention played a central role in ensuring that investors in one state could safely and reliably, securely invest in a foreign country. In addition to providing a secure legal framework for cross-border investments, investment arbitration has provided an objective and depoliticized mechanism to resolve what historically were very fraught political disputes where states sometimes threatened or even in occasions used force against one another on behalf of local investors, where diplomatic negotiations without much regard for the rule of law were the primary means of providing investment protection and resolving disputes. That's been replaced today by an objective method of adjudication, which has created, with some 1,000 investor state awards, a substantial body of international law that guides both investors, protects investors, but also provides states with substantial guidance about their rights and their remedies. I think this existing system of investor protection has been both reliable on the one hand, but also enormously flexible on the other hand, with states arriving at bilateral mechanisms and arrangements that provided them measures of investment protection and internationals measures of investment protection precisely tailored to their local needs.
Thank you, Mr. Bond. So let us directly get to the most commonly used mechanism for resolution of investor-state disputes at an international level, investment arbitration under investment treaties. Shweta, there is a heated public debate, even demonstrations in a few countries against investment arbitration and investment treaties. Can you throw some light on the basic criticisms against investment arbitration?
Sure, thanks, Kshama. So before we start, we have to understand that investor-state disputes are very different from regular commercial disputes. Like there's a state, there's an investor, there's some kind of public interest which is involved. So the crux is a little different. And there could be a perceived need to have, a possibility or a hope to have a continued working relationship between the disputing. But if there's an adjudication by arbitration, that's not really on. For example, if I refer to the arbitration of Metal Clad versus Mexico, where there was a $17 million arbitral award against Mexico, in retrospect and despite of being victorious, the CEO of Metal Clad was of the view that it was quite dissatisfying, and he wished that his company had relied on his political options than to go for arbitration. So, there's kind of a perceived backlash with the entire web of procedures, time and cost, etc., which is associated with arbitration. Now, if I have to particularly look through the lens of the host state, now it's a loser pays principle with the twist that the money, if the government loses, is going to come from the public exchequer. So that's a difference over here. And also there's a need to map out a balance of sovereignty with investor interests, hence the need for exhaustion of local remedies half of the time. Now, one of the major reasons why parties generally go for is confidentiality because of commercial reasons, etc. Now, if we look at investor-state and the arbitrations therein, they may not necessarily be confidential. Like, for example, the model BIT of India clearly says the proceedings have to be transparent. So the state may have to, publish the notice of the arbitration, the award, the procedural orders, and the proceedings can also be would be in public. So there's a lack of confidentiality in proceedings. So this is kind of a criticism which we can perceive from the lens of the host state. However, if we again go back to investors, there may be a major concern among investors with respect to the scope of reliefs which may be granted by the arbitral tribunal. For example, if I look at the model BIT of India, it says the arbitral tribunal can only award monetary compensation for breach of obligations, and that also is restricted to the loss suffered by the investor. So that's it. The compensation cannot go beyond that. Now, if we go a step further, if we look at the recently concluded India-Brazil BIT, that's a recent example that we have at hand, where the powers of the arbitral tribunal are further restricted, wherein the purpose of the arbitration is to arrive at a decision on the interpretation of the BID itself or the observance of terms thereof by the contracting state. So, this could be a matter of concern for certain investors, as to speak. So, considering all of these issues and the special nature of investment disputes as a whole, arbitrations, I can say, have faced a little bit of backlash in the recent past.
Thank you, Shweta. Mr. Bond, do you believe that some of these criticisms for investment arbitration are valid?
I think like most criticisms of anything, there is some validity and a fair amount of invalidity or fake news, if one can put it that way, with those criticisms. One of the criticisms that one hears that we just heard mentioned is the lack of transparency on the one hand, or on the other hand, the lack of confidentiality of investment arbitrations. States historically pushed, at least in some parts of the world, for greater transparency of investment arbitration, arguing that dispute resolution behind closed doors wasn't really consistent with contemporary norms. In response, investment arbitration evolved quite significantly, both in the North American Free Trade Agreement, under the ICSID Convention, under the UNCITRAL transparency rules and the Mauritius Convention, both arbitral institutions and arbitral tribunals made it possible for investment arbitrations to be conducted, frankly, more transparently than most national court proceedings and most international tribunals. If states wish investment arbitrations to be transparent, the mechanisms for them to do so are readily at hand, and one can easily, if you want to Google, find ICSID and other investment arbitration hearings that are available on the web, more transparent than almost any other proceedings in the world. On the other hand, some states, in fact, don't wish investment arbitrations to be transparent. They wish there to be a degree of privacy or confidentiality, and the arbitral process, being as it is infinitely flexible, allows states and investors to arrange their proceedings in that way, in a confidential manner. And thus, I think that criticism of investment arbitration is actually not just fake news, but almost 180 degrees reverse. In reality, unlike many judicial proceedings, the amount of confidentiality or transparency that one wishes can be adjusted precisely in particular treaty relationships and arbitrations to what the parties and what in particular the state desires. There's also been criticism of investment arbitration as involving tribunals that are not sufficiently independent and impartial. I think, again, that criticism is almost 180 degrees off. In reality, the tribunals in investment arbitrations are chosen in a time-honored fashion that is perfectly equal as between both the states and the parties. It's a classic mechanism by which each of the two parties, treated equally, is permitted to select a co-arbitrator, and then either those two co-arbitrators, the parties themselves, or an entirely neutral international institution created and funded by states selects the presiding arbitrator based on the interests and desires of the parties in each individual arbitration. Replacing that with a standing court chosen randomly and arbitrarily only by states to resolve only a specific type of dispute seems to me to be the real example of a non-independent and non-impartial tribunal. And thus, again, I think that criticism is entirely misstated. I think where there is some room for criticism is in the time and cost that investment arbitrations take. There have been a variety of studies recently, but the average cost of an investment arbitration can be anywhere between $5 and $10 million. It can take 5 years or more. That's too long, I think, for both states and investors. ICSID, fortunately, in its recent rules revisions, has proposed a number of mechanisms that will hopefully speed up the pace of investment arbitrations. The Singapore International Arbitration Center, in its investment arbitration rules, has also adopted a variety of time-saving mechanisms which hopefully can address that criticism.
Thank you, Mr. Bond. So some of the concerns such as transparency, confidentiality can be tailored in the treaty. And Mr. Bond, you mentioned impartiality of arbitrators is misstated. It may not be a really valid concern, while time and costs could be an issue. But other than that, what reforms can we bring about in investment arbitration to help get rid of the backlash that we are seeing against investment arbitration, especially as Shweta mentioned, by the lens of the host state, where a lot of these issues arise because the compensation has to be paid out of the public exchequer?
I think your question actually puts its finger exactly on what much of the criticism of investment arbitration is genuinely about. Much of the criticism has nothing to do with the procedures or the mechanism of arbitration. Those criticisms that existed with respect to things like transparency, independence of the tribunal, availability of amicus curiae participation, consistency of decisions, have all been answered, and yet criticism continues. The reason for that criticism has not to do with procedure or process. Instead, it has to do with outcomes and results. It has to do with, as your question rightly points out, the fact that some states just don't want to have to pay for taking foreign investors' property or for treating foreign investors arbitrarily. They want to be free of any process that constrains their ability to take property that belongs to others or to do things fair to foreigners. And I would suggest that is not a valid basis for criticizing investment arbitration. It's a basis for changing settled customary international law and treaty law that provides substantive protections against expropriation, denials of fair and equitable treatment, and the like. Those states ought not to conclude bilateral investment treaties and ought not to enter into multilateral investment protection treaties. If they wish not to be constrained by international law in how they treat either foreigners or their own citizens, they ought not to subject themselves to international law. But if they do, as many have in order to attract foreign investment, then they ought not to criticize procedures which actually work extremely well.
So it is indeed a matter of agreement between the host states, which decides whether the host state will be bound by international law or refuse to pay compensation and thereby violate international law despite agreeing to a bilateral investment treaty. But while investment treaties provide for an investor to state dispute mechanism, we are witnessing a gradual inclination towards state-to-state dispute resolution, such as in the recent India-Brazil VIT that Shweta mentioned, which does not have a mechanism for the investor of the home country to bring a claim directly against the host state, but the home state itself is entitled to bring the claim on behalf of the investor. Now, this could actually put us back in history where diplomatic protection was availed of by the investor to espouse its claims. Mr. Bond, what is your take on state-to-state dispute settlement mechanism over investor-state dispute resolution?
I think your question is a good one and a very important one. I think you're exactly right that these proposals for replacing investor-state arbitration with state-to-state arbitration are a substantial step, in fact, a giant leap back into the 19th century. They remind one of the era of gunboat diplomacy and espousal of claims, which fortunately the 20th century put to rest, both with the Nuremberg trials and subsequently with the innovations of the ICSID Convention, bilateral investment treaties, investment contracts with provisions for investment arbitration. I think replacing investor-state arbitration with state-to-state arbitration reintroduces the politicization of investment disputes, which ICSID was designed specifically to attempt to remedy. It gives the stronger state versus the weaker state greater power than it has been provided under existing protections. It takes the investor out of what is well and truly its own dispute and instead introduces a much more cumbersome derivative action of sorts where the state must act on behalf of its national. That approach seems to me to be particularly misguided given the complaints that exist from both states and investors about the time and cost of investment arbitration. Having a derivative action simply creates more time and more procedural obstacles that will introduce further costs. I think in almost every respect, these proposals are ill-considered. If one looks at how that type of mechanism in the WTO has functioned, I think one can see very well how, as a practical matter, it's a very poor substitute for what we already have. Of course, it's better for states to settle their disputes between themselves by arbitration than some other means, but replacing investor-state arbitration with only state-to-state arbitration seems to me to be a substantial leap backwards.
Thank you, Mr. Bond. Moving from disputes resulting in legal battles and proceedings, the commercial world is fast moving from adversarial modes of dispute resolution to conciliatory or amicable modes of resolution. Mediation is almost a corollary to dispute resolution today. Vyapak, do you believe that mediation can be an effective remedy for investor-state disputes that involve both public and private international law elements and are not strictly commercial?
Sure. I think when you say are strictly not commercial, I do not know whether that is true, because what one can award is only the monetary award. So at the end of the day, it basically goes into the very root of commercial nature of the claims made by the investor, and which ultimately emanates from some kind of a commercial contract or an investment made by the investor based on which the claim is. I think the roots are very much commercial, though the remedy may be under the BIT regime. The debate obviously keeps continuing whether BIT itself is a commercial arbitration or not, but at the end of the day, the roots are very much commercial. So whether it should be mediated, I think I don't see a reason why one should not try. And I don't know how much of that would be successful. But the treaty disputes and the dispute resolution clause do provide for cooling off period. Now, whether that cooling off period is only for negotiations, whether that is for formal mediation, can we introduce what we have a layered arbitration clause or layered dispute resolution clause as part of state investor state dispute resolution clause to bring more formal mediation? I don't see any downside there. So yeah, I think my vote would go for it. Question is, when at one end there is a state involved and on the other end there is an investor involved, one has to be very, very innovative to bring about a solution in terms of a mediation, because both parties have a very different expectation when they start off. So yes, a very strong yes to the suggestion, but I don't know how much of that would be successful.
So picking up on the point on whether or not mediation will be successful for investor-state dispute resolution, Mr. Bond, do you believe that parties can and must agree to providing binding force to mediated settlements in an investor-state treaty dispute? The answer would appear to be yes, but being the devil's advocate, what would be the pitfalls of providing binding force to mediated settlements, considering varying bargaining powers of investors and state governments, or interests of investors against the host state?
Well, I think I'm unpersuaded by the devil's advocate in this particular instance. I think mediation does have a host of benefits. If parties, whether states and investors or simply commercial parties, are able consensually to resolve their disputes in a negotiated fashion, it seems to me that that's the best possible means of dispute resolution. You shouldn't force people to arbitrate or litigate their disputes. And it's in that spirit, I think, that a remarkable number of states supported by business around the world concluded the Singapore Mediation Convention that provides for binding enforcement of settlement agreements arrived at through mediation. I think that's a recognition that mediation can play a very important role in a whole host of both commercial and other disputes. States themselves use conciliation, mediation, good offices to resolve their own disputes. I think with respect to the disparity in bargaining power between states and foreign investors, that is a fair concern, but existing principles of international law, notions of duress, unconscionability, and the like, provide sufficient protection for both states and also investors against coerced agreements and the like. That risk already exists even without mechanisms for conciliation and mediation. If a state wishes to, if I can put it this way, strong arm an investor into an undesirable settlement, it can always attempt to do that, whether or not there's a mediation mechanism. I think, if anything, a formal mediation process probably introduces a measure of transparency and discipline into the negotiation process that provides better protection for both parties. I do think one has to be careful with respect to how one categorizes and treats cooling off periods and periods in bilateral investment treaties or contracts for negotiations and mediation prior to arbitration. There are complex issues of jurisdiction and admissibility that arise in those cases, and which one should be careful not to allow to stand in the way of access to adjudicative mechanisms in arbitration if those become necessary.
Right. So we have looked at investment arbitration as a remedy, state-to-state dispute resolution, mediation. Additionally, the model of an investment court or a multilateral investment court has been floated by the European Union in its trade and investment agreements. Vyapak, do you believe that the multilateral investment court can be the solution to some of the criticisms around other modes of investor-state dispute resolution?
Sure. I think whenever a system gets a little bit, normalized, right, and things are moving in a direction, obviously there would be criticism, and there would be some amount of constructive criticism, some amount of destructive criticism, as Gary was talking about. I think one fair criticism which we all agreed on this panel was the cost associated and the time taken. Now, question is whether this multilateral courts would address this criticism to start with, because that seems to be at least something which is common and agreed upon so far as the criticism is concerned. I'm not sure. Yes, you may not have to pay hefty amounts in reference to the arbitral tribunal cost, but then what would be the additional cost which each country would bear, or each party would have to incur to go to a particular court? And in terms of time, again, how many courts, how many judges, who would appoint, how long a dispute would take instead of having separate tribunals running in parallel. Again, I do not know whether that can be addressed on that count. The other two criticism, of course, is in relation to transparency, which obvious answer would be, okay, it's a court proceedings, therefore they are transparent by its own nature. But in terms of any prejudices, or in terms of what we call is state-side arbitrators versus investor-side arbitrators, how things would be the process of appointment of judges, how transparent that would be for one to be sure that they would get a fair and a reasonable hearing, depending upon which side of the world they are coming from. So I think I do not know whether it's a complete solution, but yes, if someone wants to choose court over arbitration, I do not see why that option is not provided so far as investor-state arbitration is concerned, which I think in a commercial arbitration, we have SICC in Singapore or some other international courts that we have seen also operate on the basis of choice of the parties. The second part about the multilateral courts is that whether there can be some sort of a marriage between the arbitration and the courts. In what I mean to say is, can there be an appellate body in form of a court which is accepted as part of the treaty dispute clauses, where only for very, very limited issues or grounds, one can still go back to the court, knowing that sometimes arbitrations are run and have their own uh, shortcomings or weaknesses. So I think while this topic and these discussions are happening for more than couple of years now, but we'll have to wait and watch as to how this is formed and the manner of participation across the world. We do not want another argument of who forms this from a Western world versus the Asian countries and so on and so forth. So I think it has to be done in a much more inclusive manner. Then only this can be a good alternate or at least a second option to the arbitration.
Thank you, Vyapak. That is extremely helpful analysis on the pros and cons of having a multilateral investment court. Let us return to the traditional remedy of litigation in host state courts. Before initiating investment arbitration or other modes of resolution under the treaty, foreign investors could consider exhaustion of local remedies in the host state. Mr. Bond, with state judiciaries being more commercially robust and independent today as opposed to the Calvo times, do you believe that returning to the classic remedy of exhaustion of local remedies in contemporary times would be a workable solution over investment arbitration?
That's an excellent question, and I do have some views on it. I'd start by disagreeing with at least part of the premise of the question, which is that today, as compared to the late 19th or early 20th century, national courts around the world are more commercially robust and more independent than they were historically. Although that may be true in some cases, I think if one looks at the findings of organizations like Transparency International and other NGOs that have looked at judicial independence and other measures of impartiality in national courts around the world, one sees a rather different picture. If anything, I think national courts today in many parts of the world are even less independent when it comes to matters involving the state, when it comes to issues of foreign investment protection than was historically true. I think for that reason, foreign investors overwhelmingly would prefer access to a neutral, objective international tribunal. That's the reason that the ICSID Convention has been such a success. It's the reason why there are 155 or so contracting states to the convention and 3,000 or so bilateral investment treaties, almost all of which are based on the essential premise that a foreign investor is not required to exhaust his or her local remedies. There may be some exceptions in the case of denial of justice, where international law has provided a specific requirement in particular cases for exhaustion of local remedies. But overwhelmingly in the last decades, the requirement for an exhaustion of local remedies has, in my view, rightly been rejected. Providing access to neutral, independent international adjudication is, in my view, essential to the framework for international investment protection.
So, picking on the thread of local remedies and litigation under relevant national law, how about proposing a national legislation dedicated purely to resolution of investor-state disputes? India has recently proposed a special legislation in this regard, and we are inviting stakeholder comments on such a legislation. Mr. Bond, would you recommend that states must adopt a national legislation dedicated to investor-state disputes? Are there any success stories internationally in this regard?
Well, that's an interesting topic. There are a number of states around the world which have adopted specialized investment promotion and investment protection regimes. Underneath that label is a wide variety of different types of provisions that genuinely seek to promote and protect foreign investments, and in other cases, provisions that seem almost to have the opposite intention. I think very much depends not so much on the label, but instead on what actually is contained substantively and procedurally in the foreign investment legislation in a particular jurisdiction. If those protections, both substantive and procedural, are robust, then the state will attract more foreign investment, which is presumably its desire. If they're not robust, or if they're counterproductive, then I suspect the opposite will happen. In some states, with relatively minimal additional local legislation, treaty protections have provided a fairly robust means of protecting foreign investment and attracting foreign investment without, on the other hand, opening up the coffers of the state to any comers.
Right. So let me move a step further into the realm of Indian courts and enforcement of treaty awards here. Moazzam, are treaty awards enforceable in India? How have Indian courts viewed enforcement of investment treaty awards as opposed to international commercial awards?
So I think treaty award enforcement is it's a completely different can of worms when it comes to India. You know, as you know, all of us and all the participants would probably know that enforcement of arbitral awards, foreign or domestic, is something which is governed by our Arbitration and Conciliation Act. And that act basically discusses, you know, three broad type of awards: a pure domestic award, an award arising out of an international commercial arbitration seated in India, and an award arising out of an international commercial arbitration seated outside India, which is a foreign award. And so what made things really tricky were two decisions which have come from the Delhi High Court, which kind of have thrown a spanner in the enforcement of treaty awards in India. The first one was of course the Vodafone case. The underlying application was simply an application seeking an anti-arbitration injunction. But what the court ventured into was, it said that a treaty award cannot be enforced under Part 2 of our Arbitration and Conciliation Act for a variety of reasons. It said that, although a bilateral investment treaty constituted an arbitration agreement between a private investor and a host state, it gave rise neither to an international commercial arbitration nor a domestic arbitration. Then it went on to hold that, investment arbitration disputes are fundamentally different from commercial disputes, and that roots of investment arbitration disputes are in public international law, state obligations, and administrative law, and are not commercial or not contractual in nature. Then another reasoning that the court gave was that India had, while acceding to the New York Convention, India had made a commercial reservation under Article 1.3 to apply the convention only to differences arising out of quote-unquote legal relationships, which are considered quote-unquote commercial under quote-unquote national law of the state. Making such declarations. So, basis these principles, it went on to hold that even if you have a treaty award, you come to India, the Arbitration and Conciliation Act is not a mechanism under which you can enforce such a treaty award. Now, this case was subsequently upheld in another case of Delhi High Court, which is a very recent 2019 judgment in Khaitan Holdings. And placing reliance again on the Vodafone case, it said that foreign treaty awards cannot be enforced under Part 2 of the Indian Arbitration and Conciliation Act. Now, that kind of suggests that at least the current view of the court seems to be that under the current mechanism of enforcement of arbitral awards, which is applicable, which is available for international commercial awards, that mechanism is not available for treaty awards. So the safer bet would be to say that it will be really difficult. I wouldn't say impossible, but I would say it'll be really difficult. Anybody seeking to enforce a treaty award in India will have a fair number of challenges.
Can you also throw some light on how other common law jurisdictions deal with enforcement of treaty awards?
Well, it would really depend on jurisdiction to jurisdiction. For some jurisdictions, like the US, the UK, they have actually come out with, even Singapore, they've actually come out with legislations, setting out that any treaty award will be enforceable as a decree of a high court or some sort of a decree, some sort of an enforcement mechanism is given. And that is something which is currently absent in India. So unless you have that sort of a mechanism, things will be, again, it'll be difficult. So that and it's the same. It's England. I think the UK as well has the same situation. Singapore has the same situation. See, treaty award enforcement, in any case, you won't find many cases around the world. Even in an arbitration-friendly jurisdiction such as Singapore, there aren't many cases where enforcement of a treaty award is being sought in Singapore. In fact, I am not aware of a single one. I may be wrong, in which case there'll be very few, but at least I'm not aware. So again, it really depends on whether or not your national legislation has helped you to give you a mechanism to actually that enforcement in.
Thank you, Moazzam. Mr. Bond, what is your view on what Moazzam mentioned was the view of Indian courts, or let me say the Delhi High Court, in treating investment treaty awards as non-commercial, so as to fall outside the scope of the Indian Arbitration and Conciliation Act?
So a couple thoughts on that. First, it is quite correct that in some jurisdictions, the United States, the UK, elsewhere, there's specialized legislation with respect to one type of investor-state award and also agreement. And that is specifically implementing legislation for the ICSID convention. Thus, if you have a pure ICSID convention arbitration, there's a specialized statutory mechanism for enforcing those types of agreements, and also, even more importantly, perhaps recognizing and enforcing the ultimate award. However, as we all know, a substantial number of investment arbitrations are not ICSID convention arbitrations. They're instead conducted under a different mechanism, whether it's UNCITRAL rules, ICC rules, Stockholm Chamber of Commerce rules, Singapore International Arbitration Center investment arbitration rules, or otherwise. Almost all states, I think other than India, have treated both the agreements, i.e. the underlying treaty for arbitration, and the resulting investment arbitration award in those non-ICSID convention cases as commercial, and therefore subject to otherwise applicable national arbitration legislation like the UNCITRAL model law, and also subject generally to the New York Convention. And that's been true in the United Kingdom. It's been true in the United States in a variety of different cases. The US Supreme Court decided the case BG Group versus Argentina that arose out of the UK-Argentina bilateral investment treaty in a non-ICSID convention context. I think, therefore, the better view is the majority view, and in my view, the better interpretation of both the model law and the convention is that commercial has a broad meaning, an expansive meaning that readily encompasses foreign investment, which, after all, has pretty fundamentally commercial roots and purposes. And thus, I would hope, obviously speaking from quite afar and with the greatest of respect, I would hope that the Indian Supreme Court would see its way clear to join its brethren in other states in treating non-ICSID convention investment arbitrations as commercial within the meaning of the Indian Arbitration and Conciliation Act.
We hope the same too. Thank you, Mr. Bond, for that very helpful point. And now, before we move to the Q&A, Mr. Bond, let me invite your perspective on this final question. Do you believe that the investor-state disputes landscape provides a right ground for innovation? How can we approach settlement of investor-state disputes in a more effective manner?
I think that's a good question. It's one that is on the minds of many, including the UNCITRAL working group that is examining that. I think that the existing framework for investment promotion, protection, and the balancing of rights between investors and host states has an enormous amount to commend it. I think that system, as I began by saying, has provided a secure, reliable, and fair framework for foreign investment over the last decades. There are some 3,000 bilateral investment treaties that have been signed, many of which are still in force, most of which provide for investor-state arbitration. The overwhelming majority of investor-state awards, 60% or so, arise from those bilateral investment treaties. And I think they have done an extremely good job in balancing the rights of host states, their policy space or their regulatory space on the one hand, and the rights of foreign investors. I think they've created a subtle and nuanced body of international law, which serves as a model both substantively and procedurally for other areas of international law. I therefore think one should proceed with caution, with considerable caution, in fixing something that, by all estimation, isn't really broke. I think that continuing procedural reforms, allowing for more flexibility with respect to time and cost, allowing for greater assurances with respect to independence and impartiality, seeking to promote more efficient means of treaty shopping and restricting treaty shopping are all desirable steps. But I think fundamental changes to the architecture are, as I mentioned previously, really smokescreens for a different agenda, an agenda which seeks to dilute, to take away international protections and replace them with something very different. And I would be very skeptical of those types of suggestions.
Great. With that, we have come to the most interactive part of our webinars, the Q&A from our participants. I see a question here from Anurag. And Mr. Bond, maybe you could answer this question because you also touched on the state-to-state dispute resolution mechanism under the India-Brazil BIT. The question is, will the return of the state trend as evident from Brazil's model BIT benefit capitalist economies, which would mean basically benefit capital exporting countries?
I think it's difficult to say who precisely, if anyone, would benefit from a state-to-state mechanism replacing investor-state adjudication. I think there's a substantial chance that nobody at all benefits from it, that it simply costs more money and takes more time because you're introducing derivative actions instead of direct actions. I think it increases political tensions and interferes with the settlement of what are effectively commercial disputes by repoliticizing them, making two states as opposed to a private investor and a foreign state the actual litigants. I think it introduces foreign policy concerns more directly into the settlement of investment disputes. And therefore, I suspect all countries, whether capitalist, socialist, or something else, will be harmed by that approach. If anyone is benefited by it, I'm not sure who it would be.
There's another question from Kevin. Would the creation of a multilateral investment court ensure greater consistency in the identification and application of investment law as compared to independent arbitral tribunals? Mr. Bond, what would be your view on this?
I think one might initially think, well, it would necessarily increase the uniformity and consistency of investment law and investment decisions, investment protection decisions, because you would have one single decision maker in all cases, as opposed to a number of different decision makers, as we currently have with investment arbitration in different arbitrations. I think, though, one needs to take a hard look at that premise, because it looks at things at a snapshot in time, looks at the court as a single panel of judges at any particular moment in time. And as we all know, time doesn't stand still, and the composition of courts also necessarily will not stand still. You look at the political controversy that surrounds appointments to courts, whether, as we know in India, the ICJ, or as we know in other countries, the composition of Supreme Courts. And it is a highly controversial issue that results in sometimes dramatic swings in the decisions of the particular tribunal in question. And I therefore am skeptical whether, in fact, a single court, as it evolves and changes in composition over time, would in fact produce uniform results. I also think that the question betrays a sort of simplicity that isn't accurate, that doesn't reflect the complexity of international investment relations. It is premised on the notion that there is a single body of international investment law that is uniform on every corner of the globe. And of course, that's not true. One of the wonders of the architecture of the existing investor-state mechanism, investor-state protection mechanism, is that it is so flexible and so nuanced. Different countries, whether it's India and Brazil, whether it's the United Kingdom and Argentina, whether it's Switzerland and Uruguay, have negotiated their own tailor-made investment protections, both substantive and procedural. And it is entirely appropriate, given that landscape, that there in fact be what look to be inconsistent decisions. They're of course inconsistent because states have adopted different measures of investment protection and different types of procedure for different types of disputes among parties from different jurisdictions. And therefore, adopting a unified investment court aimed at producing a unified international investment law is actually to force a very nuanced and complex international investment landscape into a single one-size-fits-all solution, which actually would benefit nobody in the long run.
Right. I see two more questions, which are, would you agree that denunciation might be a possible strategy by states to neutralize massive claims that may arise out of the COVID crisis? And there's another one from Pranjal, which also covers COVID-19 scenario and investment. I would urge Pranjal and Anurag to tune into our webinar on Monday at 3 p.m., which deals exactly with investor state claims in the COVID arena. With that, may I invite Vyapak to give his points as a final point on this topic before we move to the closing.
Yeah, I don't think when Gary is speaking, anybody else can have a final view on any of these topics. But I think a lot of discussions, particularly on innovations in BIT regime, has been talked about since last couple of years. This has been a hot topic so far as India is concerned, particularly because this was never a topic of discussion till the time white industries happened, and then there were several cases post the 2G spectrum case and other tax claims which came about through Vodafone and other parties, and then the mining right claims and so on and so forth. So I think which obviously led to not extending the treaties for almost 56 countries so far as India is concerned. This was also happening in parallel to a lot of other countries, as Shweta and you rightly said in the beginning, that the criticisms around BITs are growing, particularly the Western India and Asia divide, which is happening in terms of the kind of awards that we are seeing. So I think definitely this is a topic which requires much more debate and discussion. I think innovation is a key at this stage because everyone is taking a very strong and extreme positions. The model BIT, which India produced in 2016, the new model BIT itself is leading to a lot of criticism. And then now we are seeing state to state. So everyone is trying, several different ways to handle this situation. But I don't think, like what Gary was saying, that after a lot of debate and discussion, ICSID brought about a specific change and at least a common platform to many problems that the world was facing at that point in time. I don't think that kind of a phase has come in terms of evaluation of treaty disputes. So yeah, I think we need to continue discussing some of these positions that different countries are taking, and hopefully India will also have little more balanced approach as we go forward. Moazzam, any final thoughts from you before we go to Gary to close it?
I think final thoughts can only be Gary's thoughts. My thoughts will be the interim thoughts. I think just taking on a point that Gary had mentioned, that perhaps the Supreme Court will step in and clarify the enforcement regime. We all hope that the Supreme Court does it. The only other way out we see it is possibly a state legislation clarifying things or a state action clarifying things. Now, you mentioned the new model BIT. That itself has a provision that all treaty awards would be enforced under the New York Convention, treated as a New York Convention. But then the question is whether that itself will have a force of law. All these these issues are making things a little difficult when it comes to just the enforcement question, and also making India such a treaty
Also, there is lot of disturbance. I don't know from which end, but we could not hear you in last 20 seconds. But maybe we are just
I think
closing.
somebody just kept on mute. That's fine. I think we can just move on to Gary.
Yeah. Sorry about
that. I see Nishith Bhai here. Nishith Bhai, would you like to just make some final points before we move to Gary Bond for the closing? Okay, I don't think Nishith Bhai can hear us.
I think time is right.
Mr. Bond, would you
come and say the final word?
Yes.
Yeah, Gary.
Mr. Bond, any final points on this topic before we finally close?
Just very briefly, firstly, to congratulate you and Nishith Desai on putting together a highly important program on a very topical subject of interest. I think that the controversy that surrounds investor-state arbitration, not just in India, but everywhere, the controversy that surrounds bilateral investment treaties, the ICSID Convention, the Energy Charter Treaty, really underscores the importance that lawyers involved in investment arbitration, in international arbitration generally, need to do their very best to ensure that the process, that the procedures work in accordance with the desires and expectations of their clients, of both foreign investors, investors generally, host states, and commercial parties. I think making the system work, making the procedures actually function in a cost-effective and efficient manner is the best response that one can have to many of the criticisms. Criticisms of the sort that we see of investment protection have more to do with broader political and cyclical changes, with reactions to globalization, where investment arbitration may be a convenient poster child, but really is not the main concern of critics. And the best defense to that type of episodic criticism and hostility is not to throw the baby out with the bathwater, not to fix things that are actually broken, but do our best to make these things function as well as they possibly can. I think we all owe the system we inherited and to our clients as well. Thank you.
Yeah. So,
Thank you, Mr. Bond. Yes, Nishith bhai.
I'm so sorry, I got cut off just when I was about to speak. I was attending the entire session, except 1 minute late in the beginning. My previous webinar was going on and I got late, so couldn't join. But you are fabulous. There's so much insight you have in the subject, and your answers were so crisp, a very good exposition, and I thoroughly enjoyed that. We have over 500 and some 20 people on the, I think, today's webinar, and everybody has benefited tremendously. And I think we look forward to on Monday's conversation further. I don't know you are there or not, but your blessings will always be there with us. This has been a subject of great interest to us, both from theory perspective and from a practical perspective, both. So it's very exciting, and I'm very, very happy that you could join us today. Really grateful to you, and give the benefit of educating all of us around the world. So thank you, Gary, and thank you, Vyapak, Kshama, Moazzam, all of you. Such a wonderful interaction. Thanks a lot, and thanks for participating.
Thank you so much.
Thank you.
Thank you, Nishith bhai. Thank you, Mr. Bond, for your time and for this extremely enriching session.